An unusual professor, sticking to time. Thank you very much, Aaron. You started out saying that you came here 20 years ago. We are now going to hear from Judge Kenneth Keith about the present cases for the International Court of Justice. Your Honor.
Thank you. Well, thanks very much, and thanks very much for involving me in this. I've mentioned to one or two people that I'm a one-time professor as well, but I've got used to other disciplines over more recent years. My topic is in a way very limited. It's about the settlement by peaceful means of international water disputes. Now, the point was just made very well by Aaron that what we're concerned with here is a continuing situation of managing this very important and very scarce global resource. It's not possible in many situations to find a tiny dispute and to think that you can settle that and that will resolve the problems. The issues are much bigger, and I thought the point he also made about the basket approach is a really very important one. It's something that New Zealand, in its small ways, has had experience of in dealing with bigger issues with other countries. Sometimes it does make sense to mix together things that seem completely different because it produces wins in various parts of the overall settlement. But my task is the limited one of looking at dispute settlement by arbitration and adjudication in respect of international water disputes. You've got a list there of, I hope that was put out on the seat just recently, of under 30 cases over quite a long period. And there are a number of things that are striking about that list. One is the point that was just made, that most of them, a good number of them, are recent, and others are a very long time ago. You even find at the top of the second page Helmand, a word which I don't think I was aware of until relatively recently in respect of Afghanistan. And there too there's the San Juan, and coming to the list, the San Juan is still with us. We decided a case, the 2009 case on the list, on the first page, relating to that old treaty, the relations between Costa Rica and Nicaragua, and we have two other cases before us right at the moment, the ones that are listed at number 13 and 14. And it is striking that most of these cases in the International Court have been decided very recently, and so far as arbitration is concerned, there's the Indus case, which has already had a good deal of mentioning. Now, what I thought I would do in my 15 minutes or so was to just run through the subject matter of the disputes, number one, second, the law that was applied, and third, the limits of adjudication and arbitration, really the limits of lawyers. I was struck by the reference to Cyril Radcliffe early on. For those of us in the legal profession, we think of him as something of a giant in the law as a judge, but I think very early on I read about his work in India and drawing the boundaries, and it was not a good piece of work. He knew absolutely nothing about that part of the world, and as was indicated, he wanted to get out of there quickly. So lawyers have their limits, plainly. Now, talking about the subject matter of the disputes, some of them are boundary disputes. One that's not on the list, one that is bubbling along at the moment, is the dispute between Malawi and Tanzania. There was a reference earlier, I think, to Lake Malawi or Lake Nyasa, depending on your view. And there is a mediation process underway which might conceivably lead to an arbitration or an adjudication by the International Court. And in that case, that runs back, thinking of the treaties that were signed late in the 19th century and into the 20th, that runs back to an 1890 agreement between Germany and the United Kingdom, which was primarily concerned, so far as those two large empires were concerned back in 1890 with Heligoland. They dealt with Zanzibar, and they drew some boundaries, and the boundary treaty was relevant as well to the dispute between Botswana and Namibia, which the court decided a few years ago. So there are a number of these cases which are boundary disputes. Others are about the allocation of water. There's already been reference to the Nile. That's not come near adjudication or arbitration, which is understandable. And there again, if you go back to the 1929 agreement between Egypt and the United Kingdom, you can understand why, because it provides for Egypt and to a lesser degree Sudan to get the lion's share of the waters, and there is an Egyptian veto written in there. So that plainly is completely inadequate, and I was struck by the expression, in this situation you should talk and you should argue and you should try to resolve the matter in that kind of way. Now, next, there are disputes about rights of navigation. One recent case that we had about that is the 2009 case I mentioned between Costa Rica and Nicaragua. And there we were concerned with an 1858 treaty written in Spanish, with a good deal of argument about whether there was some special understanding of that language in Central America all that time ago. The expression in question was in English, for objects of commerce or for purposes of commerce or with objects of commerce, and the questions that arose were, did we take the wider meaning of purposes rather than objects like a pen or something of that kind, and if we took the wider definition, did that include passengers? Did it include tourists? We discovered in the course of this examination of this case that Mark Twain had once sailed up the San Juan River in a boat owned and operated by the Vanderbilt Corporation at the time when this was potentially going to be the Panama Canal for that area in the middle of the 19th century. But then there were other questions. Nicaragua is the sovereign over that river. The right bank, the Costa Rican bank, is the boundary between those two states, and the current cases that we have relate to those sorts of issues. Now, what power did Nicaragua have to regulate the use of the river? Could they, for instance, regulate for environmental purposes? I'll come back to that briefly in a moment. In other major cases, there have been environmental issues and commercial issues, as in the Argentina-Uruguay case about a pulp mill, or two pulp mills at one point, that were to be built on the Uruguay River. Argentina complained that this was a construction that would damage the river, would be a breach of the 1975 treaty between the two countries, the statute for the River Uruguay. And a case slightly earlier is the Hungary-Slovakia one, relating again to major works on the Rhine that Hungary ceased to build at a certain point, and that gave rise to litigation. That case actually is still before us, because to go to the point about ongoing processes, the judgment of the court, as the parties requested, did not provide all the final answers. They are to negotiate, and every year or two we get a report about where these negotiations have got to, and so that conceivably could return. There's the Indus River arbitration that's already been mentioned, with that interim award that was given earlier in the year, and one case that does go back slightly longer, the Gut Dam case relating to Lake Ontario between Canada and the United States. And then finally, in terms of the subject matter, there are cases from time to time about institutional issues, and there are a couple of cases there relating to the Commission for the regime relating to the Oder River, and the case relating to the Danube Commission. So a range of different topics, and courts and arbitrators have been asked to deal with those. Now, where does the law come from? To come to a second heading before I get to the limits of law and arbitration and adjudication. There are relevant treaties. I've already touched on some, and earlier there was a reference to 500 in recent times in this part of the world. One figure that I've seen is 2,000, but that figure goes back only to 1156. It doesn't go back to Charlemagne, which I hadn't heard about until this morning. Some of them are multilateral, some of them are regional, and most of the ones in issue are bilateral, as with the Argentina-Uruguay case and the cases relating to the San Juan. Now, these agreements present a range of issues. Let me just run through some of them. One issue will be whether, thinking of the colonial ones, whether they're binding on successor states. In the Botswana and Namibia case, the states there accepted that they were, but obviously that could be the subject of dispute, or is the subject of dispute. In the case of the Nile, if you think of the upstream states that were then under United Kingdom administration, and it may also be an issue, I suppose, in the Lake Malawi, Lake Nyasa dispute. A second question, which I touched on a moment ago, is how the treaties are to be understood as time goes by. If you've got an 1858 treaty, as in that case, the San Juan case, what is the extent of Nicaragua's powers of regulation? It can plainly regulate it, but can it regulate, for instance, for environmental purposes? Well, the court said yes. It said that some treaties are written on the basis that it's contemplated that pressures and interests and so on will change, and to protect and preserve the aquatic environment and to prevent its pollution and so on may well be appropriate. You find the same sort of thing being said in respect of the much more recent treaty, the 1975 treaty, in the Argentina-Uruguay case. If you go back to that time, environmental impact assessments were known, but not very widely. They were just starting to be developed. You'll find some state legislation in the United States. You find, again, to be parochial, you'll find a government direction in New Zealand in respect of government works in 1974. But here we're just 2 or 3 years after the Stockholm Conference. But by the time we came to write our 2009 judgment in the pulp mills case, sorry, it was a year later, I think, wasn't it? We referred back to the earlier one. We said that the convention was to be interpreted in the light of later developments, later understandings, and so there you find a bit of flexibility written into the legal process. And another aspect of reading a treaty in context is seen in the Gabčíkovo-Nážemáros case, the Hungary-Slovakia case, where there's some interesting discussion of whether Hungary could escape its obligations in various ways by referring to a state of ecological necessity, new developments in environmental law and so on. So the law is not always as wooden and stuck in the past as it might appear. And the court in that case, the Danube case, said the treaty is not static, it is open to adapt its terms to emerging norms of international law. Environmental norms, said the court, can be incorporated in the joint contractual plan. So the treaty is not to be seen as an island entire unto itself, it is to be seen in that wider context. And then the wider context will sometimes include these very broad propositions that you find, for instance, in the transboundary convention that was mentioned earlier, the non-navigational uses treaty, which still is to come into force, which you find as well in the European Convention relating to transboundary waters. Some very broad propositions about no harm, about no significant harm being caused, about reasonable and equitable use, and so on, and about the principle of community of interest, which you also find in one of the old decisions of the Permanent Court. So there are these wider principles, but that brings me to my last point about the limits of adjudication and arbitration. If you've got those very broad propositions, they're quite often not going to be a way to resolve the particular case. If you're a country thinking of litigating, if you're the lawyers advising them, if you're the judges on the receiving end, what do you make of these extremely broad propositions? How do you apply them in concrete situations? And I here go back to a point that's been emphasised and which I should have probably put earlier in this brief account, and that is that the procedures, good process is critical in so many of these areas. And it's interesting that in a number of areas of the law now, in a number of bilateral contexts, regional contexts and multilateral ones, there is a lot of emphasis on the duties to monitor, to notify, to consult, and to exchange information, and to cooperate, thinking of the word in the UN year resolution. And so there is a growing emphasis, a growing recognition in the legal system that very often the real answer is to begin with good processes, to have good institutions, to have good information, and to go back to those three Ins: information and institutions and infrastructure. So just to make a final point about adjudication and arbitration, it can be seen as a good thing in that it may not be possible for governments actually to settle the dispute by agreement. They may be near agreement, but they may want some third party to endorse it. New Zealand again has experience of that. Or they may not like arbitration or adjudication because they lose control. It's now just a bunch of people over in the other building who make these decisions, and are they really the people you want to resolve these really difficult matters? There may also be concerns if people are thinking of going to court or going to a tribunal of three kinds. One is the choice between different institutions. The second is the choice of counsel. And the third, and an important one, is the whole business of cost of some of these processes. So my final point really is to go back to something that's been emphasised, and that is that many of these matters are best handled by management, by managerial processes based on good information. They're not going to be well handled if they're divided up into tiny little fragments which people think can be resolved by courts and arbitrators. That will not always be the answer, although, as the list shows, it is increasingly seen as the answer in respect of matters that are seen by governments as being capable of resolution in that way. Thank you for your attention.
Thank you very much, Your Honour. This is an informative opening session, and being in the Peace Palace, it's very important also to be informed about the work of the institutions in the Peace Palace, including the International Court of Justice and also the Permanent Court of Arbitration. There will be a speaker this afternoon from the Permanent Court of Arbitration. So thank you very much, and I'm sure that Aaron has some of the answers and you will continue talking afterwards.